watching the India development debate. I'm Tamanna Inamdar. The top court has rejected a clutch of petitions seeking a review in the controversial Rafale case decision. The court reiterated that there is no need for a roving inquiry in the case, which the main opposition party, the Congress, had made a key political plank before the general elections earlier this year, claiming corruption in the procurement of 36 Rafale fighter jets from French firm Dassault. Soon after the top court's order reiterating its earlier stance, the BJP has claimed victory, asking the opposition to make amends for their false claims. The Congress, meanwhile, has stuck to its guns, demanding a joint parliamentary committee probe based on part of the order authored by Justice K.M. Joseph. In fact, Rahul Gandhi has tweeted saying this order opens up the doors to an investigation into the Rafale case. So is it time to lay to rest the ghost of the Rafale controversy? To speak on this and more, I'm joined today by Prashant Bhushan, top lawyer and one of the litigants in this case, Colonel Ajay Shukla, retired senior journalist and expert in strategic affairs, Abhijit Iyer Mitra, senior fellow at the Institute of Peace and Conflict Studies, and Hitesh Jain, lawyer and spokesperson with the BJP. Welcome to all of you and thank you for speaking with us today. Mr. Bhushan, I want to come to you first and simply ask that the Supreme Court once already said that there was no need for a probe. It has reiterated its position. What next? Or are you now ready to move on from the Rafale case?
Well, the Supreme Court has not gone into the in detail into the issues that we had raised in our review petition, but they have just said that once the final decision has been taken by the highest authorities in the government, and because the court is not technically equipped to go into these technical issues, therefore they dismissed our review petition. That's the majority judgment or the judgment of two judges. But the third judge, Justice Joseph, has clearly said in his judgment that the facts mentioned in our complaint to the CBI certainly disclose serious cognizable offences being committed by the Prime Minister and other people, and therefore according to the Constitution bench judgment of the Supreme Court in Lalita Kumari, the CBI was duty bound to register an FIR and conduct an investigation into this. However, because of a recent amendment that this government made in the Prevention of Corruption Act by adding 17A, which requires the prior permission of the government before the CBI can embark upon any corruption investigation, therefore they say that the CBI should proceed to take the permission of the government and then embark upon that investigation. That's the judgment of Justice Joseph, which has not been differed from by the two other judges. The two other judges have merely said that we are dismissing this review because we are not technically equipped to go into all this, but they have not said that the CBI should not register an FIR and should not conduct an investigation. This fact has only been mentioned by Justice Joseph.
Okay.
This aspect has only been gone into by Justice Joseph, and who has said very clearly and categorically that it is the duty of the CBI to conduct an investigation, but of course after taking the permission of the government. And the question that I want to ask is, if the government is so clear about having done nothing wrong in this deal, why does the government not permit its own caged parrot at least to conduct a proper investigation into this deal? What's the problem?
Okay. So you are still sticking to your guns on Rafale. You're still sticking to your guns on Rafale, saying that there should be a CBI inquiry. Hitesh, in your sort of dual capacity, BJP spokesperson, and you're of course a lawyer as well, the Justice Joseph portion of the order has been quoted by Rahul Gandhi as well, saying it opens the door to investigation, and this question has been reiterated time and again. Why not have an investigation? Do you see the need?
Merely because someone resorts to falsehood and vulgarity, that is not a ground to justify any inquiry. The Supreme Court has categorically stated that what the petitioners were demanding was fishing and roving inquiry, and today also while dismissing the petition, the Supreme Court has clearly said that this is nothing but a roving inquiry. On the contrary, the Supreme Court has gone one step ahead, that these are the petitioners, they want to act themselves as an appellate authority, they want to scrutinize each and every fact, and then they want us to get into the facts. Now, as far as Rahul Gandhi is concerned, I think the court has clearly given him a message that he should not use the court for the political discourse. And today, I think Mr. Prashant Bhushan, he should be also mindful of the fact when he starts to put the words in the mouth of the Supreme Court judges that we are not technically equipped to pass the judgment. He can show a single paragraph where the Supreme Court has said that they are not technically competent or technically equipped to deal with the issue. On the contrary, the Supreme Court clearly said that the petition lacks merit, petition lacks bona fide, and they don't want to conduct a roving inquiry. So, you cannot start to pick, oh, but this, oh, but that. Today, all the issues raised in the review petition have been comprehensively dismissed. Okay. You cannot say that, oh, one judge said this, oh, one judge said that. Well, it is a legal position, but on that legal position also, the one thing is very clear, falsehood cannot replace the facts, and the fact is merely because someone is resorting to falsehood and vulgarity, you cannot demand an inquiry.
Okay, I don't know what exactly you're referring to when you say vulgarity, but then that is the word that you have chosen. But I think Prashant Bhushan should respond to a very specific point.
Vulgarity is the language used by Congress, and the vulgarity is
there are two aspects
by the Congress and
so there are two aspects
during the run-up to the election.
So Hitesh, there are two aspects to this entire case. One is the political back and forth of it. One is the technical part of it. We're obviously covering both, but as you note, I have no one from the Congress party over here. So I've got lawyers and defense experts on the panel today.
Well, the language of vulgarity was used by Mr. Prashant Bhushan also.
But I think since you've talked about Mr. Prashant Bhushan, I should give him a chance to respond specifically to the charge that you made. Has the court said that they don't have the technical capacity to review the case? I remember in the first judgment, the court did say it is not for us to decide what should cost how much, and they've reiterated in this judgment, that it is not in our capacity to say which aircraft should cost how much. Is that what you're referring to? Yes, Mr. Bhushan.
Yes. So the court has said, the sort of majority judgment in this have said that once the matter has been dealt with by the highest authority of the government, the court would not be embarking into a detailed inquiry into what we have said. And the court has also said, as this gentleman from the BJP pointed out, that we are trying to become the appellate authority in this matter.
Okay, one by one, please.
So now, yes, they have said that. I can point out that paragraph to you or that part to you. But what I am pointing out is, what you said was that the court has said that we are trying to treat ourselves as the appellate authority. So what I am saying is that Justice Joseph in his judgment has clearly said that he has said that yes, our prayer for a CBI investigation and registration of an FIR in accordance with Lalita Kumari's case has not been dealt with. This is at page 53 and 56 of his judgment. They said that
Mr. Bhushan, you are a senior lawyer, and you will. What is the net effect of the verdict of the Supreme Court? The review petition stands dismissed, and the Supreme Court has not suggested for filing of FIR.
One by one, Hitesh. One by one.
He has said that it is true that the court has been misled on the issue of that Dassault was in negotiation with Reliance earlier. They mistook the elder brother for the younger brother or his company.
But Mr. Bhushan, they also say that it is not relevant to the case because it is
not relevant to the case.
It is Dassault who chooses, who to give offset contracts to. The court also does say that. I mean, the broad picture is...
They have said that, but they have also... They have also said that it is beyond dispute that the complaint discloses serious cognizable offences.
Right.
So they have also said that the CBI can and should take prior permission of the government under section 17A.
Can. Do they say should? Do they urge the CBI to do that? You know, the point
last
is...
sentence.
Yeah.
Yes.
No, so...
Yes, they have asked the CBI to do that. They say, however, it is my view that the judgment sought to be
The
reviewed
point is
would
you are
not stand in
misinterpreting
way
the order,
of
Mr.
the first
Bhushan. We will file a
respondent, that is
contempt
CBI,
petition against you.
from
We will hold
taking
you to this
action.
Okay,
court
one
and we will
minute.
file a contempt petition
Let
tomorrow
Hitesh
itself.
respond. 1 minute.
in
Let
accordance
Hitesh
with
respond.
law.
1 minute. Let Hitesh respond. You're reading from the judgment. We'll put out that part which you're referring to. Let Hitesh just respond. Hitesh, that is his interpretation. That is
Last
his
paragraph.
interpretation. The overall order unequivocally
Tamanna,
rejects all the review petitions. The question we are asking in this debate is it time to move on from Rafale and the case? Prashant Bhushan says it's no, he's not willing to move on. I'm going to go now. Allow me to now go to Abhijit Iyer and Ajay Shukla. Thank you for your patience, gentlemen. Because in the broader question of is it time to move on from Rafale, both of you, and I've had the opportunity to speak to you before, have been on differing sides on the merits and demerits of the entire Rafale case. So, in answer to that basic question, let me start with you, Ajay. You have argued often that there is something fishy in the way the procurement process has gone forward. Now that the Supreme Court has said once and then rejected the review petitions also, do you think that it's time to lay this to rest?
Before we go forward and assume that it is time to lay this to rest, let's remember, Tamanna, that there is still the opportunity for the petitioners to seek the CBI's actions in the matter. As Prashant Bhushan has absolutely correctly brought out just now, Justice K.M. Joseph's concurring note opens the door for that via Section 17 Alpha of the Prevention of Corruption Act 2018. Now, the logic that will be deployed here is that, as Prashant Bhushan correctly brought out, the two-judge note, that's the Chief Justice and Justice Kaul, have indeed said that they are not technically qualified to rule on this matter. And just to satisfy the BJP spokesperson, I'll read out the exact points they said. They said this is, I quote, not a function of the court. It left best to the judgment of competent authorities. An interval mechanism or an internal mechanism for pricing is adequate. So the court has declined to interfere in this matter owing to such matters best being left to the technical authorities. But the fact is that the door is still open for opening further investigations by the CBI, and that could well be taken by Prashant Bhushan, Yashwant Sinha and Arun Shourie. We'll have to wait ahead and see how that goes. But coming to your question about what has to be done with this aircraft now, the horse has already bolted. The stable door has been left open. We have already bought and paid for 36 Rafale.
Yeah.
The matter is by and large closed. We have bought those aircraft. We cannot back down from this deal now. And coming to the next question of, the next 114 aircraft which are in the process of being procured, it seems to me that the position is we will have to buy more Rafales at this point in time for the simple reason that we've already paid so much for developing the India-specific enhancements of this aircraft that we now have no choice but to go ahead and go further down the Rafale path.
Yeah. Okay, Abhijit, do you agree with that broad assessment? Rafale, whether it's a good idea in the first place or not, now has become irrelevant because it became a huge political issue. But now that we've, gone this far, what is your point of view of how this goes forward?
Look, whether it's a good deal or not is different from whether it's a corrupt deal or not, all right? Now, the thing here is I've never liked the Rafale, I would never wanted the Rafale, and I would have been much happier if I never bought the Rafale. But that's a completely different issue from if there was corruption in the Rafale. Now, see, the thing is, I think K.M. Joseph's additional statement that Rahul Gandhi just tweeted out, he is basically saying that you've ended this particular avenue of appeal. If you want to take up some other avenue of appeal under the Prevention of Corruption Act, go ahead and do that, because there's many avenues of appeal open to you. But you know, this is a bit like if you want to relaunch an investigation into the JFK assassinations, or if the moon landings were staged in a TV studio somewhere in Hollywood. You can keep on with these conspiracy theories, you can keep on with these you know, delusions. It ultimately it was a political accusation meant for an election, which has now came you know, crumbling down. You didn't get any electoral or political gains from it, so if you want to proceed with it, go ahead. As for the 36 Rafales, well, look, the reason it was chopped down to 36 is because it was too expensive. I think anybody that thinks we can procure more Rafales, not really feasible given our defense budget. We've got a huge shortage of single engine aircrafts coming up. As we know, the LCA is a walking talking disaster. They're now talking about Mark II, so they're consolidating their failures by even more failures, and they want to consolidate that second failure with an even bigger failure stillborn called the AMCA. So by all means, you want to waste public money and go ahead with all of this, go ahead. Right now, I think the priority is for a single engine small aircraft that you need in large numbers, not these expensive little you know, exhibition aircraft.
No, I want to talk a little bit further on that, because at the end of the day, the politics is on one side. It's basically the need of the Indian Air Force to have these aircraft. So important point there. Ajay, I just want you to respond you know, to what Abhijit said right now. So are we going to get more? Do we need to get more? Can we afford to get more? Because as you said, we've already got the first tranche, so there's no way we're going back.
Oh, well, are you asking me, Tamanna?
Yes, Ajay, that question's for you.
Yes, there is already a procurement underway. The process has already been launched for buying another 114 aircraft, that is 6 squadrons of additional fighters. This is all in addition to the domestic effort of building more light combat aircrafts at Tejas LCA and the AMCA, where I don't agree with Abhijit. I think that indigenous effort is vital and extremely important and has to go ahead. But at the same time, this process of buying 114 more aircraft will be launched. It's already underway, in fact, and we will have to make the decision about whether to buy expensive twin-engine aircraft or go in for a cheaper single-engine version that might well perform almost the same role, but not quite the same role, but would be within our budget. The fact is, our budget is deeply strained, and with the economy going in the direction that it is, the budget is not going to grow at the rate that had been anticipated earlier. So all in all, we are in a tight corner as far as aircraft is concerned, and we'll have to cut our coat according to our cloth.
Okay, so that is the real picture. I thought it's very important to focus on this because that's the real picture and the expert view of what Rafale really means. Unfortunately, it's become more of a political issue, and let me come back to that aspect. Hitesh, the fact now that Prashant Bhushan today, Rahul Gandhi is tweeting, all of them are now demanding a JPC. Do you think that that's something the BJP would consider?
Well, Tamanna, again repeating, falsehoods cannot change the facts. The fact is how many times they are going to bite the dust. The Supreme Court earlier said that they will not entertain a fishing and roving inquiry. Thereafter, on 23rd May 2019, the people of India made them bite the dust. Today also they have bite the dust. So it is for them to take a course as to how many times they are going to, we will make them bite the dust again and again. People like Prashant Bhushan, Rahul Gandhi, they have been frankly speaking exposed. They have no face to show. They tried to drag the courts in the political discourse. They tried to put the words in the mouth of the court. So when they have realized that they have been exposed, that falsehood has been exposed, people of India clearly know as to what language the Supreme Court has said. And when the Supreme Court clearly says the petition lacks merit, the review petition lacks merit, and we are dismissing, after that you cannot pick one observation here or there and then try to say, oh but this, oh but that. I mean, the law is there. If they want to do anything, they can do, but at the end of the day, they cannot change the truth with the falsehood.
Yeah, Mr. Bhushan, I must ask you, and we'll keep the contempt portion for Rahul Gandhi out of it because there's no way that you could respond to that. Despite that, the fact that Rahul Gandhi is today tweeting out when he has been sort of got a rap on the knuckles for evoking the Supreme Court's name, the fact that the Supreme Court time and again, and not just once but twice, has said this. So how really do you think you can take this forward?
See, in my view, the Supreme Court has not dealt with the main issues that we had raised. They only said that under Article 32, given the limited nature of this jurisdiction, given the fact that we are not the body which will go into all these facts about pricing or the details about who gave the offset contracts, etc.
Yeah.
Therefore, we decline to entertain or decline this review petition.
Yeah.
See, they have not gone into all the issues that we have raised even in our review. The issue regarding the fact that the Prime Minister bypassed all the rules and signed a deal for only 36 aircrafts without any make in India by giving offset contracts to Anil Ambani. This has not been gone into in
One
this
sec.
judgment.
Okay,
The fact that the Defence Ministry itself said that the PMO is
But
conducting
they have
parallel
not found merit in it.
negotiations
1 minute, let
in
Hitesh
this
respond. They have
deal
not
has
found
not
merit
been
in it.
gone into-
Mr. Bhushan, all of these points were argued before the court. They have not found merit in it. Yes, Hitesh, you were trying to say something. One by one.
But they
Speak
have
one
not
by
dealt
one.
with them. They
Okay.
have just said. They have not dealt
Tamanna,
with this.
2 points.
Yeah.
All these points which they wanted to raise, the Supreme Court have dealt with it, and they say that point by point they say they want us to act as an appellate authority on each and every issue, which is not permissible to do so because there is no sufficient material. Second, they say we do not find any merit. Now, when such language is used, we do not find any merit, and when the Supreme Court says that there cannot be a fishing and roving inquiry, the meaning of when Supreme Court makes such observation that fishing and roving inquiry means that the substance and material placed before the court are so frivolous that the Supreme Court does not even want to take the cognizance of such material. So, if the substance is so frivolous, if they do not have the material, where is the question of demanding an inquiry on the basis of
Let me-
Because if the Supreme Court says there cannot be a fishing and roving inquiry,
Yeah.
how do you demand
but
a
the
JTC
Supreme
on
Court,
such
the
kind of
Supreme
a
Court's order is
fishing and roving
108
inquiry?
pages. Okay, there's 108 pages. They've made it very clear that they're dismissing all the review petitions. They're saying no need for fishing and roving inquiry, but they're also saying in the end, and I've read that portion, Hitesh, they're also saying in the end that if there is clearance to proceed, then you may proceed. Am I understanding it correctly? That this is now
Tamanna, that
becoming
is
a
not the
political
way the
decision.
Supreme Court order will be interpreted.
No, fine,
Tamanna, I'm
fine.
again trying to educate you and the viewer.
Thank you, but I'm
you have
asking
to look
you a
at
question.
the order of the Supreme Court. The effect of today's order
No,
is
absolutely.
review petition
I'm
has
asking
been
you a
dismissed.
different question,
ET
Hitesh.
now cannot say that the Supreme Court has told
I'm
that
asking you a
prosecution can be
question,
filed.
Hitesh. Can you hear the
Supreme Court
question,
has not
please?
said.
No.
It is the concurrent
1 minute.
observation of one of
Hitesh,
the
can you
judge.
take my
But that is
question,
not the
please?
order of the
Hitesh, is
Supreme
your audio
Court.
not working? 1 minute. I'm saying, does it now then boil down to, educate me further, does it now boil down to a political decision at the end of the day? And what does that mean? Because what it really brings questions
No.
about is the Prevention of
Simple
Corruption
answer,
Act.
Tamanna. Simple answer, Tamanna.
Yeah.
The order will mean that the review petition is lacking merit and it is dismissed. The order cannot mean to say that merely there is a concurrent observation of one of the judge, that means that the Supreme Court has given them the permission. Well, the Supreme Court does not give the permission to file a criminal complaint. The legal remedies are available and any person can avail those legal remedies. That is our independent legal remedies. But the order of the Supreme Court will mean to be read today is that the review petition lacking merit has been dismissed by the Supreme Court, except that you cannot give any other interpretation and meaning and effect. And if I can challenge Mr. Prashant Bhushan, if he wants to go and obtain the clarification of the Supreme Court that we meant to say that file a prosecution, because he will again invite a contempt like Rahul Gandhi invited against himself.
Mr. Bhushan, you want to
We
respond to
cannot
that?
mislead the people.
You want to respond to that, Mr. Bhushan, very quickly?
Well, we are. we are writing to the CBI director tomorrow morning itself, asking him to immediately take permission of the government in accordance with this judgment and proceed with the investigation. That is what the Supreme Court has ordered. The two
So be
judges
prepared
who
to
have
have one
given
more
a
egg on your
separate
face, Mr.
but
Bhushan,
concurring
again.
judgment have not said anything against it. That's what the Supreme Court has ordered. That's what
so
they have said.
Very
that
often, I'm
according
here.
to the law
Very
declared
often,
by the Constitution
the lawyers
bench.
choose to interpret and sides choose to interpret as they see so fit. But for all practical purposes, let me now round up and come back to Abhijit and Ajay. For all practical purposes, the whole attempt, I would say, and I'm coming to you first, Abhijit, the whole attempt to put Rafale under a cloud of suspicion, would you say that now it has effectively failed, and all further attempts from here on are really going to be, very poor ones, considering that the Supreme Court has said not once but twice that it does not see any merit in pursuing this?
Look, I think this is flogging now a dead horse, beyond the corpse of a dead horse, really. I don't see where it's going to go from here anymore, because there's no more smoking guns left. All the smoking guns, all the procedural issues that have been raised have all been shot down. That said, I would just want to make one case under the legal thing here. Basically, this was a test of section 156(3), which was the powers of the magistrate under the CRPC, all right. And basically what's happened out here is that the magistrate has said that he's not going to quash it. Of course, if he had quashed this petition, then that would have prevented the cop from also filing anything in this. He said you are now free to do what you want. If you want to go to the cop, you go. Now, if any of these people find any kind of value, either public probity value or electoral value, in taking this to a cop or to the CBI, as Mr. Prashant Bhushan is saying, they are more than welcome to do it. It's their natural whatever, but this is the law of diminishing returns. I don't know what they're going to get from it, because remember what Justice K.M. Joseph has said. He did not say that there was any evidence presented. He said assuming, because if you read that tweet that Rahul Gandhi has put out, he says even assuming that these people had put cognizable evidence in the domain. He didn't say that there was evidence, by the way. So, be my guest. I mean, it's I get to come to your TV studios more. I guess it's good for me in that particular aspect. So, be my guest. I'm happy.
Well, at the end of the day, it's about India's defense systems. And we'd love to have you over, Abhijit, but it should educate and add value to our viewers. Which is why, Ajay, the question about moving on and focusing on what has come out of this entire episode. And I think one important point is something which I experienced myself as more and more people got into the Rafale case. It came to light that our defense procurement system maybe needs a really serious relook at, in terms of the amount of time it takes, in terms of the amount of years it takes to decide on what to buy, and then the processes that follow. You think that's one important outcome?
Yes, I think that's an important outcome. I think hopefully also, and I'm only making an assessment over here, the Supreme Court's clear reluctance to get involved in questions of defense procurement might end up removing one channel of transparency, one more channel of oversight, one more channel of accountability for the government in these matters. But at the same time, I'm taking an optimistic view here. I hope it would also free open the business of decision making in defense. If decision makers in the Ministry of Defense are not constantly in fear of repercussions and retaliation against the decisions that they're taking, they might be able to take more rational decisions,
right,
even when it does not conform with the party line at that point in time.
Yeah.
So let's be optimistic. Let's hope that this will have a positive effect on defense decision making and unlock the doors for more defense procurements ahead.
Definitely. Transparency and some kind of a speed. Remember, the Rafale deal, from conceptualization to actually You know, seeing the first aircraft has taken over a decade. Let's hope that there is some movement on that front. Thank you so much to all of you for joining us on debate number 1. When we come back, a very important issue is Children's Day today. We've been celebrating Children's Day all day on ET Now. But look at the big picture. Children today are going to have to live with the impact of air pollution and climate change. The state in Delhi continues to be severe, and we've actually had some people who thought it was a good idea to get kids to run a marathon in these dangerous conditions today. The true questions on Children's Day after this very short break.